Well, howdy everyone. Good afternoon for about half the country. Good morning for the rest. I'm David Glazer.
I'm Pari Megara.
And we are here to talk about making sense out of the Medicare manuals. Just a handful of announcements. So first off, we have our upcoming webinars. So on September 11th, Deborah Schneider, our colleague, is going to be talking about sort of immigration and in particular what you need to know like about ICE showing up in a medical facility. What are the kinds of things you would need to worry about there? And so sort of how, with all of the buzz on immigration things that medical providers should know about the current state of immigration. On October 16th, it's a week later than normal because some of us do Yom Kippur, so it'll be on the 16th. We're going to do one of our most popular topics, which is grab bag. That's really all the questions you can ask. You'll get an email soliciting questions, but if right now you've got a burning question that can wait until October 16th to have it answered, you can type it in the chat box and we will throw that into our hopper.
Slow simmering question.
Yeah, but some of them are. The next month, on November 13th, telemedicine is most likely the topic. That could change. And then in December, we will be doing our regulatory update. Remember, all of our old webinars are available online for free, so you can go look at those. And if you're thinking, where are the slides are in your email. You can click on that and you can follow along at home. Last thing, if the sound goes south, you can always dial in the number Robert is typing out. And you'll want to know where the chat box is, because in just a minute, you have a chance to win a prize. There will be at least 3 prizes offered during here, so know how to. Pari's rolling her eyes at me already. It's going to go downhill from here. Okay, so here's our first prize. Making sense of the Medicare manuals. There was a band in the 80s that did a movie and an album called Stop Making Sense. The first person to identify that band will get the prize. Bonus if you know the director of the movie. All right, now just one other clarification. Some of you might be thinking that this is actually a webinar about Lin-Manuel Miranda. I know my daughter would be very excited if it was. Different Manuel, so we're going to give you the Miranda warning. Wrong webinar. All right. So what's interesting to me about this is the first time we've done this topic, and we're lucky because Pari knows a lot of administrative law and is going to make this better than I could. But in some ways, this is a Back to the Future episode because we've been giving the same advice about the manuals since I was a baby lawyer back in the 90s. And in fact, starting in, I want to say 1994, I was working on the investigational device case, and some of this manual stuff came up then. Now, an important thing to keep in mind, I'm going to walk you through sort of what the thinking was then. We would have said then, don't believe the manuals. Don't take them as gospel. That statement is still true today, but I'm not prescient. The reasoning that was around then is not the reasoning that's used today, and I would never have understood the reasoning that we're using today. And I think there's an important lesson here when you're in any litigation involving healthcare. And Pari, you've summed that lesson up pretty well at points. I think we were at once having a discussion, I don't remember if it was you or I who came up with what some would call a creative argument, others would call a cockamamie argument, but we were talking about it and the merits of using it, and you said?
Make the argument.
And what was your thinking in make the argument?
You never know. I mean, it sounds sort of silly, but you never know, and I have been practicing 6 years and I've seen the crazy argument work so much more often than I would have thought. I think sometimes courts are looking for a reason or a hook to avoid an unfair outcome, and the goal is to give the adjudicator lots of different hooks that they could latch on to, depending on their mood.
So I think there are 2 or 3 themes that you were going to hear repeated through here, and that's one of them. Don't be afraid to make the argument. It's kind of its corollary, which is be creative in coming up with those arguments. And that also is going to mean most of the time you're not going to want a refund off of the manuals because you have an argument. So, but these are themes that are going to keep popping up. So let's talk for a moment about this case. So there was a manual provision that said if a device wasn't approved for marketing by the FDA, it wasn't covered by Medicare. And that manual provision came out in 1986. So when did the government start enforcing it? Well, of course, in 1994. So just a little bit of time. I mean, what's half a decade between friends? Now, the government's arguments in that case were what I'd have to say was waka waka, and not like in the Muppet sense. So this is an actual quote out of the briefs. I don't remember if this was at the trial court or at the Ninth Circuit. It doesn't matter. The manual embodies a policy that itself is not even binding in agency adjudications. Manual provisions concerning investigational devices also, quote, do not have the force and effect of law and are not accorded that weight in the adjudicatory process. It's a good thing I didn't write that brief because I wouldn't have been able to say it. I then had a case with the government and where I'm arguing in front of the Eighth Circuit where my client had relied on some language in the manuals, in particular on an appeal deadline, and the government said, thus, if the government manuals go counter to the governing statutes or regulations of the highest or higher dignity, a person relies on them at his peril. So, in other words, this is the government saying, don't trust what we said in the manuals. Frequent listeners have seen me use this slide before. This isn't new. Pari is going to talk about stuff that is new, but this is embodying this basic idea that manuals are kind of an afterthought, okay? Now, next contest. If You Could Read My Mind, 1970s song. Who sang it? So let Robert know. There's a prize in it for you. Okay, so the government kind of wants you to read your mind. This is the crazy. So in that case, what happened was the hospitals sued for declaratory relief. Declaratory relief is when you're asking the government or asking a court to say the government can't enforce or take a particular action. And the argument that the hospitals used was that manual provision was inherently non-binding, and therefore, the hospitals shouldn't even have to go to court to defend themselves because the manual provision wasn't binding. The government's counter-argument was really interesting. They said, well, you're trying to assert that under the Administrative Procedures Act, this was improperly issued. Well, there's a statute of limitations under the Administrative Procedures Act, and that has run. And so your ability to seek this declaratory judgment the time has passed. And to my shock, that argument worked. And what's shocking about that is think about the logic here. The reason that the APA exists is to say, you've got to give notice to people about a rule. And so you can't have secret rules that you bury somewhere. You have to give notice and allow comment on rules. And so having a statute of limitations to challenge that means you have a time limit to say, I didn't know about this rule because the government didn't properly tell me about this rule. So if they do a good job and hide it for 6 years, they win. That's crazy.
Particularly if they take 8 years to enforce it, from 86 to 94.
So this is really nuts. Now, important to remember, that case didn't come out well for the hospitals. That doesn't mean they ultimately lost, because the question in the case was, do you get a declaratory judgment? And ultimately, we represented 2 clients. Now, a bunch of people paid a bunch of money in that thing. Our clients didn't pay a cent because we said, are you crazy? We're not going to pay a penny. And there are a couple of tidbits here about that. So, and there's a typo in this slide that I just noticed. So the government paid those claims for years, not just one of them, multiple years. And a law firm found this document where what was then HCFA, now CMS, had a memo that said there's nothing on a claim form that requires someone to identify device information. And that, in other words, when you submit the claim, nothing on the claim was inaccurate. To me, that felt like a sure winner. The law firm that found that, which I was really impressed with, I didn't find that, said, well, yeah, you probably should still pay because, you never know. But we were like, yeah, no, we're not paying, not only because of that, but this whole thing is unfair. Our clients didn't, in fact, ever pay any money. And I think that's one of the other lessons here is just say no can be an effective strategy. All right, I'm about to turn it over to Pari, but just a historical fact. In the old days, when I was a baby, the manuals used to be in paper. Now the manuals are electronic, which would mean we would call them e-manuals, sort of like this guy. Yeah?
I'm surprised that you chose the wrong e-manual.
What do you mean?
This is ROMA manual. You should have chosen Zeke.
Who's Zeke?
David.
Yeah.
Zeke Emanuel is a health policy and bioethicist guy. He got a bunch of press during the Affordable Care Act. He's Rom's older brother.
Okay, I've got nothing here. So Pari, hang on. Are you saying that I should have put some weird obscure reference in the slides. We don't do that.
Never.
Okay.
To be fair, it is awfully hard to tell which e-manual is the correct e-manual.
And what do you mean by that?
Well, do you really want me to explain your joke, David?
No, not the joke, but I think you mean the manuals.
I mean the manuals. I mean, it's hard to know whether a coverage sort of guidance issue will be in the NCD manual or the benefit policy or claims processing or where it might be hiding. So it makes sense to check around if you're doing research.
Okay, well, why don't you walk us through some actual stuff now that I've taken us into the weeds?
So I think the best way to start talking about the Medicare manuals is to understand how they fit into the hierarchy of authority, of legal authority. The most authoritative source is the Constitution. You wouldn't think this would have a lot of applicability, but it does. Due process considerations drive a lot of the adjudicative process. That stuff is pretty well developed under federal law, but under state law, I have written many a due process argument related to sort of banana stuff that states' Medicaid agencies do. Contracts clause can come up. It's hard to show, but on occasion the government might do something that so inhibits a provider's contracts with third parties that it could be a violation. And then you may recall the Affordable Care Act's enumerated powers issue, which was that the individual mandate to buy insurance the Supreme Court held was not an exercise of the commerce power because an individual's decision to buy or not buy health insurance was an economic decision that affected only them in their own state. The court ended up preserving that on the tax authority because there was a penalty. Since there's not a penalty anymore, that's still sort of winding its way through.
So, Pari, would you say due process, is that sort of a lawyer speak for it's not fair?
Yes, and due process has two components. It has procedural due process, which is the process isn't fair, and substantive due process, which is the substance isn't fair. The government doesn't have a good reason for doing this. And both kinds of challenges can pop up, although typically, again, my experience, more often in the Medicaid context than in the Medicare. Below the Constitution is statutes. Here we're typically talking about the Social Security Act, statutes passed by Congress. These are binding. The Social Security Act delegates authority to CMS to promulgate regulations. The Medicare regulations are in Title 42 of the Code of Federal Regulations. These are also typically binding and typically put through notice and comment rulemaking in the Federal Register. You guys are familiar with this. And then there's this plethora of program guidance underneath the regulations. This is the manuals, it's online bulletins, it's FAQs, it's, I would say, regulatory preambles probably fit into this, so the agency's discussion of the comments in the Federal Register, that's not regulatory text, but it probably is guidance. And then, as we'll talk about later, this can also encompass, say, random spreadsheets that the government posts on its website.
So we got a couple questions. We will do questions at the end, but we sometimes will take them when they're appropriate. So, Pari, what about NCDs? And maybe what we should say is we're going to talk about NCDs. We're
going to talk about NCDs. Those are sort of a special case because the Social Security Act treats them differently.
And then I just, as a throw out to someone, just want to say the word Webster. But no one will understand that. We'll just keep going.
Okay, David. So the Medicare manuals are the sub-regulatory guidance, and these are CMS's, theoretically, these are CMS's instructions for administration of the Medicare program. They're typically binding on contractors who administer the claims process. Some examples are the Claims Processing Manual, Medicare Benefit Policy Manual, National Coverage Determinations Manual. As we noted, it can be really hard to figure out if you're looking for a particular thing. It can be hard to know which manual it's going to be in. I would say that I work most often with these three and also maybe the Program Integrity Manual.
But the one thing, because I think you made this point really importantly, which is not only is it hard to know which place you'll find it, but just because you find something in one doesn't mean it's not also addressed in another.
Absolutely true.
Which is one of the tough things about doing research in this area.
Yes, I keep hoping that I'm going to get better intuition about where to look, but I think that in a lot of cases this just isn't intuitive because there's pretty substantial overlap between the manuals. The National Coverage Determined Manuals is its own thing. We'll talk about that towards the end of this webinar. The manuals in general are available on CMS's website and through third-party vendors, collection, like information services sort of deals. But a word of caution about that. Beware of Google searches. David actually found this particular example. He Googled a regulation, 42 CFR 410.32, which governs diagnostic imaging in labs. And he clicked through this first link. It's a good thing that David has this sort of insane recall of the content of Medicare regulations because he was able to figure out from looking at it that it didn't smell right. He thinks to himself, that's not what I remembered this particular page of the thousands of pages of Medicare regulations saying.
That Google page smelled terrible. So,
Stinky.
What about, can you Bing with caution too? What about Bing?
I would not Bing at all. So we're going to look at this very first hit here. So first, I'll note that this is from the CMS website, which looks awfully official, doesn't it? Doesn't that look like that's going to be a thing that you can rely on? But look, this is the October 1st, 2003 edition. This is a nearly 16-year-old regulation. This regulation can drive a car this October.
I wouldn't want to get in its way.
No, in general, don't get in the way of a regulation. So if you click through that first link, this is sort of a lucky one because it's a PDF of the actual CFR official sort of version, annual version, which means that the date is listed right there in the top corner. This problem of it being of the internet Google search pulling up a wrong version is even more dangerous if you're looking at like an HTML version or whatever. I'm not really a website person, that might be wrong. Just a version that just appears on a web page as opposed to a PDF of the actual codified code, because then there wouldn't necessarily be an effective date on it and you would have no way of knowing that it's the wrong version unless you're David and you have memorized the Medicare regulations. I have not. This comes up in particular with the Cornell website, which is often the first hit and is at least sometimes wrong. And
I would love to say that I have memory, but like I have been saved by luck a couple of times on this problem, where you look at the regulation and it turns out it has changed. So we just can't emphasize this enough.
So we encourage you, I put the links to the official versions here. The current Code of Federal Regulations can be accessed using the first link, the Federal Register, which in my like little law nerd sort of opinion, has a particularly good advanced search function. I'm sure you're all super interested in that tidbit. It's available there. And then the manuals, there's a launch pad from the CMS's website. In particular, I would be careful of the manuals because there are PDFs of those floating around all over the place on the internet.
And once again, some of them are old. You should, if you've got our slides, you can click on those links and bookmark them.
Sure. So even if you have the right version, pay attention to your effective dates. We have absolutely seen government contractors attempt to enforce manual provisions or regulations to claims occurring at a time that the substantive provision didn't yet exist. So let's say the proposed recovery relates to claims made in, 2014 or whatever, and the purported requirement that the government or contractor is attempting to enforce is contained in a manual provision which did not exist until 2016. It is unreasonable for government contractors to expect you to predict the future and or time travel, so you should be challenging that, but you won't necessarily know unless you look specifically. If you think you're running into this problem, particularly on manual stuff, the best thing to do is to try to reconstruct the manual revision history. I am not going to lie to you, this is the worst. It requires attention to detail and like being very thorough, and it's basically exhausting. David is pretty good at it, I'm reasonably good at it, and as is often the case with things that David is pretty good at and I'm reasonably good at, Katie Ilton is really good at it. So I would, if you need help doing that, please call her and not me.
So the reason for those of you who were on sound checks, you were listening to I said my daughter didn't watch a show with us. That's because she's busy watching Doctor Who. And she would love the TARDIS, which allows you to go back in time. That's TARDIS, T-A-R-D-I-S, not the tortoise, which would take you back very slowly. The reason we have time travel here is because of this situation. It's what I think Pari named it, the Time Traveling Manual. So if you look here, this is Chapter 10 of the Medicare Benefit Policy Manual. And this is the language about what it takes to be admitted as an inpatient. So if you look at the red, you can see it's revision 234. So that's going to take you to a transmittal, basically. So you could look up revision 234, and it should show you the changes that happen here. It was issued on March 10th, 2017, and it was effective January 1st, 2016, and it was implemented June 12th, 2017. Now let's just think about that again for a moment, right? So it was issued in March of 2017 and effective when? 14 months earlier. So that doesn't work unless you got the TARDIS, right? And so this is an example of how you really have to get into the weeds when you're doing this stuff. Now, this part of the text is for the 2 midnight rule. And a logical person might think, oh, I know, I bet this relates back to the beginning of the 2 midnight rule. That would be logical and also incorrect, because the 2 midnight rule came into effect October 1st, 2013. Why October 1st? Because that's the beginning of the government's fiscal year. So a lot of inpatient hospital rules and stuff start in October. So as an aside, so first, until this came out in 2017, the manuals had done nothing to take account for the 2 midnight rule. So we had a situation where we had the 2 midnight rule and regulation, and if you looked at the the benefit policy manual, it would talk about the 3 tests that we've mentioned on past webinars. You know, if you were overnight with the expectation that you would stay overnight, and then if the doctor had an expectation you'd be in the hospital for 24 hours, and then it kind of went on to say, however, the test is complicated. So ignoring how poorly written the manuals were, what they were then completely different from what existed in the regulation. When they fixed it, they backdated it. So Pari, I am subject, someone's trying to recover money from me and they're using this for claims from 2016. What do you think?
I would trace back. So the first thing I would do is make sure that whatever it is that they're trying to enforce wasn't in an effective regulation at the time. Because even if the manual is time traveling, if the regulation is not time traveling, you need to be relying on that, because those are binding regardless of whatever nonsense has happened in the effective dates of the manuals. Assuming that that's not a problem, I would argue that you don't have to comply during the period of time that you don't know about the requirement. That sounds obvious in sort of constitutional terms. That's probably a due process notice defect, and that's the sort of argument that I would make.
Well, so can the government lay a trap by having a regulation that says X and then a manual that says Y? And I'll answer my own question here, which is say, that's kind of the case I was talking about, where my client relied on an appeal information in the manual that was different from the regulation. In essence, what the Eighth Circuit said was, yeah, the government can lay that trap. I think that's baloney. I think they were wrong. What do you think?
I think maybe lay a trap is a bit strong. That sounds like bad government drafting to me, as opposed to intentional misinformation designed to make you lose your appeal rights. But who knows? Stranger things have happened. So a little bit of this effective date issue in action. So some of our colleagues use this principle in this False Claims Act case. Lucy and Hoppy and Kevin Rich, and a now retired attorney in our white-collar group, handled the regulation, and the brilliant Katie Ilton was the subject matter expert on the Medicare issues. In this False Claims Act case, the allegation was the hospital had failed to properly supervise the provision of certain pulmonary and cardiac rehab services. When Katie traced it out, she figured out that the requirements for supervision actually didn't exist until after the relevant period of time. so the district court dismissed the complaint for that reason. Eighth Circuit ended up affirming the dismissal on different grounds, but the argument is still quite good. Sort of relatedly, if you're looking for the most up-to-date version of the manual, typically you'd want this for, guiding future practice. You can look at the first page of the manual section. It'll have an effective or the revision date. So I took this screenshot on Friday night because my life is extremely glamorous and I was reading manuals on Friday night, which gives you a sense of the lag, I don't know, 2 weeks-ish. This does end up mattering sometimes. So several years ago, I was working with another lawyer here on, I think that it was authority for mid-levels to do inpatient admissions. I can't quite, maybe that was a thing, doesn't matter. And we read the manual, we wrote it up, and then she was Googling and happened to run by chance into a very recent transmittal letter that changed our conclusions. It was only by chance that she found that. So the better practice would be to look at the transmittal letters. You can also, CMS maintains a table on its manual's website of upcoming revisions to the manual, so you could also check that and see if there's something imminent on the horizon. We also recently learned that commercial databases don't necessarily update terribly well, so a commercial database containing the manuals that we have used in the past intentionally does not incorporate transmittal revisions and transmittals until they have finished, linking all the third-party or the secondary source, like enhanced content, to the treatises or whatever. The secondary source and enhanced content is great stuff, and I'm super glad we have it. But having the most up-to-date version of the manuals is probably more important in a lot of cases.
And so that's, you've paid for this service and you think it's current, and it's not.
Right.
Okay, so we're now going to spend the rest of the time, in some ways this is the whole webinar, right? Are the manuals binding? So what does binding mean? And, binding is different because people often talk about it's illegal. Like it's illegal to do this, it's illegal to do that. But illegal doesn't, it is not illegal to fail to pay your vendor, right? You can get sued, but you're not going to go to jail. So there are different kinds of binding. Can you go to jail for violating the manuals? Well, I suppose it's going to depend on what's going on, generally not. Is there an overpayment? Well, that's a really interesting question. When someone asked, well, what about the known or should have known standard? And whenever you're talking about an overpayment, remember that the government is statutorily required to waive an overpayment if you're without fault. And if the manual gives you an instruction and you rely on it, I think you've got a really good argument you're without fault and there's no overpayment. But if the manual says it's there, you might have an overpayment. We're going to talk a little more about that. Are the claims false? Well, this is complicated, and I think the short answer here is it depends, and we're now going to go through what some of the things it depends on. Remember that an overpayment is money that you're not entitled to, and so ultimately the question is going to be what arguments can you make that you're entitled to the money. So this is not about the 60-day rule, so we don't want to spend long on this, but just to make sure everyone's on the same page. You have a duty to report and return an overpayment. Remember that regulation says you have to go back 6 years. In some ways, this highlights the irony of what we're talking about. The manuals talk about a 48-month limit on reopening. And in fact, so do the regulations. And the advice we give people is that you've got a colorable argument to only go back 48 months, and you're relying on the manuals. And one of the things that I think we would thematically say, the manuals can give, but they can't take away. A manual can be looser than a statute, but it can't be tighter than a statute. Now, we would say that. Would the government agree with us?
Probably not in a lot of cases. So that seems like the sort of thing that you may end up duking it out on.
But to quote a colleague of mine, make the argument.
You never know.
So, okay, this is just, I hope most people know this sentence from Escobar. I guess it's like a paragraph, really, of those of us who failed grammar. So, to get in trouble for a False Claims Act case, the materiality standard is demanding. If a mistake isn't material, it's not a false claim. The False Claims Act is not an all-purpose anti-fraud statute or a vehicle for punishing garden variety breaches of contract or regulatory violations. A misrepresentation can't be deemed material merely because the government designates compliance with a particular statutory regulatory, or contractual requirement as a condition of payment. Nor is it sufficient for a finding of materiality that the government would have the option to decline pay if it knew of the defendant's noncompliance. Materiality, in addition, cannot be found where noncompliance is minor or insubstantial. We used to talk about conditions of participation versus conditions of payment. We're going to talk about it again in this slide. That's mostly gone, and now the question is it material? In other words, does it matter? Would the government have not paid the claim if they had known? And for a lot of what we're going to talk about, they'd have still paid. That's, for example, if you go back to the investigational device case we started this thing with, there was nothing on the claim form that asked for it. If the government wanted to know, they'd ask for it on the claim form, and the fact that it wasn't on the claim form is a good argument that it's not material. So here's the standard under the FCA. I'm just going to do this super quickly, which is it's knowledge, deliberate ignorance of the truth, and reckless disregard. And then there are a bunch of cases that say something like this. If you have a reasonable but inaccurate interpretation of the law, you don't have a false claim. So this is the kind of thing that goes in your favor. That similarly, you can even kind of get there in the overpayment thing. If you've got a reasonable interpretation, you can create a without fault argument. So remember a little over a year and a half ago, I'm blanking on her name, the author of our memo.
Brand, I've forgotten the first name.
Brand, I just need Rachel Brand.
Rachel, there it is.
I just needed the brand. It's bad when your brain goes. So, okay, the Rachel Brand, before she went to Walmart, wrote this memo explaining that the government isn't going to rely on guidance when engaged in what's called affirmative civil action, or civil enforcement, actually, affirmative civil enforcement, ACE. If you ever hear people talking about ACE lawyers in the U.S. Attorney's Office, that doesn't mean that they're really good or that they're crack lawyers. It means that they do enforcement on behalf of the government against people. They're affirmatively bringing cases. So a thing that I think gets overlooked a lot is that in a straight-up overpayment case, after you go through the ALJ and the Departmental Appeals Board, you get into district court, and the Department of Justice is then doing affirmative civil enforcement. And so I would assert that the Brand memo applies even in overpayment cases. And it backs up this idea that the manuals aren't binding.
So one thing that I think is really interesting about this memo is if you look at, the first paragraph here, it talks about guidance documents that effectively bind the public without undergoing the notice and comment rulemaking process. This memo treats undergoing the notice and comment rulemaking process as totally synonymous with binding regulations. And as we'll see when we walk through some of this case law, those are really more of a Venn diagram. So, for example, statutes creating rulemaking requirements sometimes exempt like emergency rules from notice and comment. So, and I don't know that this memo would really be intended to say if you violate an emergency but totally valid regulation, they can't take enforcement action against you simply because the agency was excused from doing a notice and comment. That said, if I found myself in that situation, I would certainly make the argument.
That's our motto for today, make the argument. Okay, we've covered this slide, and I want to get Pari going on the cool Supreme Court case. So the big question, was the claim accurate? Are we talking about something that was material? Would the government have paid the claim anyway? So Pari, walk us through the big development from June.
Sure. We're going to talk about a decision issued by the Supreme Court back in June that underscores, or that ends with the upshot that is our typical advice, which is the manuals are not binding in most circumstances, but gets there in a way that we hadn't really thought about it. This is the Azar versus Allina case. So this case involves disproportionate share hospital payments. Lots of you know this, but DSH payments are extra payments from Medicare that are meant to compensate hospitals that have lots of low-income patients for the costs of providing uncompensated care. DSH payments are calculated on the basis of this just miserably complicated calculation that draws data out of cost reports. And one component of the calculation is the Medicare fraction. Under the statute, the numerator of the Medicare fraction is patient days for patients who are entitled to Medicare Part A and are also entitled to Social Security income support payments, and the denominator is patient days for patients who are entitled to Medicare, just Medicare Part A, so a total. I think the general idea of this fraction is to calculate the fraction of Medicare patient days for low-income Medicaid, or excuse me, I said Medicaid, I mean Medicare patients. The higher the number of low-income Medicare patients, the higher the fraction and the higher the dish payment. The key question in this case was whether Medicare Part C, so Medicare managed care patients, ought to be included in both the numerator and the denominator. Part C patients tend to be higher income than traditional Medicare patients, so including them in this fraction, both in the numerator and the denominator, has the effect of driving the fraction down, which has the effect of driving down dish payments. It seems like this couldn't possibly make that much of a difference, but the Supreme Court opinion says that this was a between $3 and $4 billion with a B dollar difference over 9 years. So there's a bit of tortured rulemaking history here related to this, should Part C patients be in or out. CMS first proposed a rule back in 2003 that said that Part C patients would not be included in the Medicare fraction. In 2004, when they issued the final rule, they included the Part C patients. There were several successful administrative law-based challenges. David is reminding me to say that Part C is the same as Medicare Advantage. I don't want to be confusing. So the final rule included the Medicare Advantage patients, and there were several successful administrative law-based challenges to that rulemaking, and including arguments that the agency reversed its course without adequate explanation and adequate response to the comments, for example, and courts vacated the rule. So there was not a rule. In 2014, CMS revisited this issue and put out a new rule including Medicare Advantage patients in the Medicare fraction, but that rule is only effective prospectively from cost reporting year 2014 forward. Those lawsuits, the House bills challenged that one again, and those lawsuits are still pending. The Allina case is really about the period of time in between the vacatur of the 2004 rule and the 2014 new rule. It involves these 2012 dish payments, which were calculated in 2014 after the new rule came out. I know a lot of you already know this, but I was just like gobsmacked to learn just how long the cost reporting process takes. And so when they were dealing with the 2012 dish payments based on the 2012 cost reports, it was actually 2014 and later that we were dealing with this. Appealing a cost report related issue can take many more years even after that. I think we have pending cases involving cost reports that are 10 years old.
So on my 40th birthday, I was dealing with an issue from high school, just saying. A case that arose when I was in high school.
Right, not his own high school experiences that continue to haunt him.
That too.
So the hospitals, so to solve this problem, CMS decided to avoid the whole rulemaking process, probably their first mistake, and they just calculated the Medicare fraction for like 3,500 hospitals, and they just went ahead and popped those Medicare Advantage patients in there. And they posted their calculations on their website in a giant spreadsheet. The hospital sued based on the argument, and based their argument on a portion of the Social Security Act, 42 U.S.C. 1395HH, a really convoluted statutory citation, as they all are in Medicare. That statute lays out the process that CMS is required to use in rulemaking. Let's take a little look at it here. Here's the most important bit of this statute from the Allina case. Under the statute, it says, no rule, requirement, or other statement of policy that establishes or changes a substantive legal standard governing some stuff, including the payment for services, is effective unless CMS promulgates it in compliance with the procedural requirements of this statute. call it just a few things, the statute facially applies to more than just regulations. This isn't just about defective regulatory rulemaking. This isn't about, you know, the notice period in the Federal Register. This is not a technical violation kind of thing. This specifically includes and wraps up into it requirements and other statements of policy. The statute also tells us what statements of policy and requirements that it cares about. It cares about those that establish or change a substantive legal standard governing the payment for services. It's not like a lot of clarity on what that means. Justice Breyer in the Allina Case dissent talks specifically about this. From a regulated party perspective, a little bit of flexibility in this definition is probably helpful because it allows you to make the argument. The statute also lays out the rulemaking requirements that the agency is supposed to adhere to when it establishes or changes substantive legal standards governing payment for services. In most cases, this is going to be notice and comment rulemaking. This means CMS is to publish a proposed rule, solicit comments from the public, and then consider and respond to those comments, including maybe modifying the rule in response to concerns raised in the comments before it finalizes the rule. Note that the 60-day notice period is actually longer than the 30-day notice period that most agencies are bound by, and maybe as a recognition that Medicare rules are especially complicated. The statute does have some exceptions for rulemaking, for this notice and comment rulemaking process. So if the statute requiring a regulation to be created provides for a shorter notice period, that specific statutory provision will control. It also accepts statutes that require implementation fast because rulemaking process is time-consuming, and then it also has a good cause exception. I want to spend a little bit of time on the good cause exception. Just in case you're wondering, CMS probably can't use this exception to like retroactively bless all of its manuals because the exception requires the agency to make and publish a contemporaneous finding that the notice and comment rulemaking process is impractical, unnecessary, or contrary to the public interest. So CMS would have to invoke this at the front end. Just a little note there. Justice Gorsuch wrote the majority opinion in this case, and he was joined by Justices Roberts, Thomas, Ginsburg, Alito, Sotomayor, and Kagan. Only Justice Breyer dissented. Justice Kavanaugh did not participate in the decision because he actually wrote the the circuit court opinion from the D.C. Circuit that was on appeal. So the government had asked the court to read in an exception to that statute that we just looked at for what it calls interpretive rules. That's an exception that exists under the Administrative Procedures Act, which is a different statute that applies to most government rulemaking, but doesn't apply to CMS. There have been a handful of cases in the lower courts over the last 20, 30 years that had preserved manual provisions against sort of rulemaking-based challenges on the grounds that they were exempt from notice and comment rulemaking as interpretive rules. All of those cases are, I think, bad law now. I don't think that they work anymore. And so this does upset that body of law. The court specifically rejected the government's invitation to read a bunch of stuff into a statute that isn't there. That's consistent with the sort of textual focus of a lot of the current justices. Justice Gorsuch, writing for the majority, stuck to the plain language of the statute. He noted that the spreadsheet expressed CMS's policy, which pretty clearly affected a legal right relating to payment of care to the tune of $3 or $4 billion. The government warned the Supreme Court that invalidating the spreadsheet would imperil the entire Medicare Manual system. Justice Gorsuch was basically like, no biggie. He wrote that only 8 manual provisions had been preserved on the basis they were interpretive rules, and that no challenges to manual provisions had come out in the 2 years since the District of D.C. decision that was on appeal in this case had been issued. I don't know if this is really a good argument because I'm going to make this argument a whole lot more now, and so maybe this only 8 could get a lot bigger. Justice Breyer was not so casual about this concerns in his dissent. He would have read the APA's exception for interpretive rules into the Social Security Act. He was especially concerned about the manuals. He noted that there are, quote, tens of thousands of pages of manual provisions, which seems approximately right from my experience. He also included a list of the provisions in the provider reimbursement manual that courts have saved on the basis that they were interpretive rules. This is not good law anymore. If you would like to scan through the dissent and see if any of these provisions affect you, they are easy to find from a formatting perspective because he includes this handy bullet point list. So if you're interested, easy to find right in the opinion. Two important caveats here. First, remember the hierarchy of authority. If a manual provision is inconsistent with the reg wins. If a reg is inconsistent with the statute wins. If a statute is inconsistent with the Constitution wins. Conversely, or is it inversely, I can't actually remember, if the manual is consistent with the regs and the statute, CMS may be able to successfully argue that the reg or the statute is actually the source of the authority. In this case, the government had, in my opinion, a pretty good argument based on the statutory text. Medicare Advantage patients are, by definition, entitled to payments under Part A, under traditional Medicare. That's one of the requirements in order to be enrolled in the Medicare Advantage program. And so the government probably didn't need to rely on the spreadsheet. They could have just relied on the statutory text. The Supreme Court held the government waived the right to make this argument by failing to raise it. That's just bananas. The second caveat is that
the bananas part is that they didn't raise it, right? I mean,
oh yeah,
it's amazing that they didn't raise it.
Yes, that's what's bananas. I think the doctrine of waiver is a handy judicial tool for avoiding arguments that are hard to resolve. So it doesn't surprise me that the Supreme Court would have invoked it. The second caveat is that Justice Gorsuch noted that notice and comment would not, rulemaking procedures would not be required for CMS pronouncements that merely, quote, fill gaps in the statute because these gap-filling policies don't, establish or change substantive legal standards as required by the Social Security Act provision that we looked at here. So it's worth asking, is there any difference practically between an interpretive rule, which the Allina case tells us is not a thing under the Medicare statute, and a gap filler, which Justice Gorsuch tells us would be A-OK? Okay, so I don't really know. Maybe, maybe not. This seems like an area that's going to get some development. So a gap filler doesn't change or establish the legal standard. Okay. And an interpretive rule doesn't have the force of law but explains the agency's interpretation. Seems like this is going to be a Venn diagram that's like pretty close to circular in some cases, although we're going to sort of talk it out and, again, make the argument.
Okay, so let's try to operationalize this a bit. So we're going to do a couple of examples, physician signatures and concurrent surgeries. And physician signatures is an interesting one, right? So do you need to sign a chart? Well, there's nothing in the statute. There's no regulation, all right? So where does that leave us? So first question, if the manual says something about signatures, is that going to be filling a gap? And to remember, the agency can fill gaps. That's okay. They can't do interpretive rules. And I think this language is in some ways confusing, but so they can't make something up, but they can fill a gap, all right? So if a manual has a requirement that you must sign something, is that creating a new rule or is it filling a gap? What do you think, Bari?
So it probably depends on how it's being used. If the government is asserting that the failure to have a signature and the requirement only appears in the guidance, and that the government's trying to recoup money on that basis, I would say that they are attempting to bind you to that requirement, and I would argue that that is a binding requirement and not a gap filler.
That to me feels really binding. It's creating something that wasn't there, and if they're denying payment on it, to me that does not feel like a gap filler. That feels like a new rule.
Sure.
Okay, now let's change reality. Let's say there was a regulation that says a physician needs to sign something, and the manual says you can't use a stamp, or the manual says the signature has to be in black ink, not blue ink. Gap filler or new rule / invalid interpretive guidance?
So I think the weird thing about that example is that if the government attempted to take money back on the basis that you used a blue pen instead of the black pen, that is like a really stupid thing to do. That seems really unfair. But it also seems like the sort of detail-oriented gap filling that might actually be preserved. Not surprisingly, I'd make the argument.
So yeah, so I'd be worried that I think what you're saying is a court might say it's within discretion, but it feels so unfair.
Right.
Now, we're going to talk about this in a minute again, but there's a difference between the position you're going to take on an internal review and a position you take in an overpayment case. On an internal review, there's no way on earth I'm refunding money off of an ink color kind of argument, right? Okay, so we have done this signature thing a bunch of times, and we don't have a lot of time, so I'm going to blow through this one quickly. But remember, according to the manuals, if the signature is missing from any other medical documentation other than an order, you're supposed to accept the signature attestation. But if the signature is missing from an order, according to the Program Integrity Manual, you deny the claim. Well, guess what? There's higher authority that contradicts that. Halloween 1997, when IDTFs, Independent Diagnostic Testing Facilities, were created in the Preamble. So the Preamble is text at the beginning of a regulation where the notice and comment Pari keeps alluding to comes up. People write in comments and the government responds. And the government said, hey, commenters are saying, why do you require specific orders in an IDTF when you don't do the same in physician offices? And the answer is because IDTFs, well, in this case, IPLs, which were independent physician labs, were bastions of fraud. Well, this makes it clear that there is no requirement in a physician office for a signed order. Actually, take it back, written order. If you don't have to have a written order, you don't have to have a signed order. Whoever wrote that section of the Integrity Manual skipped reading this part of the Federal Register, all right? So we're just going to blow through that. Another quick example, and I want to mention this one because this was literally a $15 million question for our client. So you got a teaching hospital, a surgeon is working with a resident on 3 cases. One's being opened, one's being closed, and the third is in the key portion. So the teaching physician is in the key portion. And someone comes up with manual language that says when there are 2 overlapping surgeries, if you've got 3 concurrent procedures, the teaching surgeon is supervisory and it's not okay. Okay? So that's in the manual. But what the regulation says, even the manual says that the teaching physician isn't required during the opening and closing. Let's look at what the regulation says. In the case of a surgery, the teaching physician's presence isn't required during the opening and the closing. It's right there in the regulation, more specific. And so I would say that that manual wasn't gap filling, it was imposing a new requirement. And we did not refund that money, and that was a decade ago. So where does that leave us?
So what good are the manuals? We just got a question that's sort of related to this about whether the manuals might be entitled to judicial deference. So I think that is a potential issue, so we can talk a little bit about what that is. People think about judicial deference as being the Chevron doctrine. I think that probably doesn't apply here because Chevron is applied to the agency's interpretations in a regulation.
Chevron is a Supreme Court case.
Yes, sorry. Chevron is a Supreme Court case, and it has a particular sort of test for whether a court should defer to an agency's proclamation of policy, but that Chevron applies to agency regulations and their interpretation of the statutory text. I think we would be in a little different situation here. One possibility is that manual provisions would get deference under a case called Our. The Kieser case is from this past year and also talks about this. The Our and Kieser standard talk about interpretive rules. As we just discovered in Allina, these are not the manuals cannot be interpretive rules because that is not a thing that exists under the Medicare statute. So query whether this would even apply. I would make an argument, if this were my problem, that the more flexible standard established in the Supreme Court Skidmore case applies to manual provisions. That's a Supreme Court case that talks about how rulings, interpretations, and opinions of an agency are to be treated. They do not control the court, and they are entitled to basically as much weight as they deserve. The court says that the weight they get will depend on the thoroughness evident in the agency's consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all of those factors which give it the power to persuade. That's a pretty flexible standard. I would love it if that was as much as manuals get.
Hey, we got so caught up in this, I missed my last contest. So this is an 80s song. One of my favorite groups growing up had a song which is very fitting for this because we're talking about gap filling. They had a song, Into the Gap. East is east and west is west. Keep going out into the gap, more or less. If you know the group, you win a prize. Okay, so Pari already talked about this statute, but this statute is gigantic. Manuals and guidance can't limit coverage. And so let's go back to this statute. No rule or other statement of policy other than a national coverage determination can limit coverage. Now, an important thing to keep in mind there, that means an NCD can limit coverage. So NCDs are special. They are higher on the pecking order. I'm just going to mention this really quickly because we're running shortish on time. So there was an investigation, the implantable cardiac defibrillator case started probably in 2010. And the government said, hey, there's an NCD, and the NCD says you don't get to put in an implantable cardiac defibrillator if you're within, 45 days of an MI or 90 days of a bypass. Well, they failed to read the opening part of the National Coverage Decision Manual because that explains that when you've got an NCD, unless it explicitly says that something isn't covered, it doesn't limit coverage. It only grants coverage. So if you've got an NCD that says, we will cover this scan if the patient has a fever of 104 or is from Texas, that doesn't mean that the service can't be covered when the person is from Oklahoma. It just means if they're from Texas, it's covered. The only way the person in Oklahoma is uncovered is if the NCD explicitly says there is no coverage for people in Oklahoma. So that's easily missed and misunderstood and causes people to think that they're out of compliance with an NCD. At times they are not.
Okay, it's like 15 seconds on LCDs. These are not actually even issued. These are local coverage determinations. These are not even issued by CMS or issued by CMS's contractors. They're limited in geographic territory to just the contractor's territory. Weirdly, they are subject to notice and comment, which is very strange. We typically take the position that LCDs are not binding. They're expressly not binding in administrative appeals, so they're not binding at the request for reconsideration stage of the appeals process on qualified independent contractors. I actually did not know that until Friday night when I found it in the statute, which is sort of embarrassing. They're definitely
I didn't know it either.
And they are definitely not binding on ALJs pursuant to CMS's regulations. I put this citation into a False Claims Act case that did in fact hold that failure to adhere to an LCD rendered the claims false under the sort of kooky reasoning that guidance can be mandatory. I think this case just gets it wrong, but you should know it's out there.
But the two of us not knowing this is an important point to make, which is this stuff is really hard. And when you get into it, like before you go giving a bunch of money to someone, explore all of these arguments, dig, because there's often stuff you didn't know.
Just a quick note about Medicaid manuals. This is a state law issue, so these principles don't directly apply. States have their own principles of administrative law, which can be even friendlier in some cases.
We should mention Katie Ilton, who is our hero, has found this example. You can have these same problems where the state Medicaid program enforces things or doesn't follow its own requirements, like where they apply a condition that is, or they use a review tool, whereas the regulation specifically requires them to use a different review tool.
And then it turns out they don't have a copy of the review tool that they were required to use. So principles of administrative law vary from state to state. Minnesota has this great doctrine called the unpromulgated rule doctrine, which is basically if it didn't go through the notice and comment rulemaking process in accordance with state law, it is an unpromulgated rule and is invalid. Wisconsin has also put a fair amount of effort into just dismantling any deference that agencies would get. So those are states in which we don't worry all that much about that.
Okay, so let's look at some takeaways. And this is our last slide, and we'll have questions in just a moment. So be skeptical of the manuals is obviously a message that we've had thematically in here. If you're thinking of refunding because of something that's in the manuals, you almost certainly should not be doing that. Oh, and jump back 1 second. To private insurance companies, just as an aside, they have manuals. They're usually incorporated by contract, and so it becomes purely a contractual question of whether you are contractually required to follow their thing. If you don't have a contract with them, you can blow their manual off. If you do have a contract with them, you have to figure out if the contract requires you to follow their manual. Okay, so refunding based on the manuals isn't a good idea. You got to trace the requirements in the authority, and the details really matter. And we're going to go on this in a moment, but we're doing something new and different, and I just want to put this up. We have a Rorschach test today. So if you're nerdy and you want to link to either Pari or I on LinkedIn, and you have the LinkedIn app, if you open that app and put it up to the screen right now, you will automatically link, which is, I think, super creepy. And I'm a little freaked out by the whole thing, but we'll just leave that up while we continue with our questions and stuff like that. It's quick and creepy. So we've got we got a bunch of questions here. So one, what about HHS secretary rulings? Those are higher in the regulatory authority. There's a process for that sort of thing. And so they are more likely to get a precedential effect. It's akin to a form of rulemaking, basically. Mm-hmm. The secretary is issuing a rule. We've got a question here. I don't know if I totally understand that one, so maybe we will follow up with the person. This is a good, how do you not return money when they're just reaching into our bank account and taking it back? Well, first, Medicare should not be doing that. Medicare sends you an overpayment letter and you got a right to appeal from that. Private insurance is its own ballgame, and if they're doing that, then you'd have to go with your state insurance commissioner or whoever regulates your state insurance. But Medicare isn't supposed to take the money back unless you fail to appeal within 30 days of the redetermination. If you appeal within 30 days, they're not supposed to take the money. The icky thing is once you get to the administrative law judge level, then they can take the money back. There have been a couple of court cases where courts have said, given the long wait at the ALJ level, they shouldn't be taking that money, but that's yet to be determined. What other questions do we have here? Let's see. Looking to see if we're missing. I think we've answered the question about NCDs. This may be it. So while we'll wrap up here, I will first mention a few reminders. If you thought that this wasn't too painful and you want to force someone else to watch it, sometime around Friday, you'll get an email with a link to the video, and people can watch this. The next webinar on September 11th will be about what healthcare lawyers need to know about what's happening with immigration in the world. And then please remember to send us your grab bag questions, because that will be October, and hit us with as many questions as you want. What am I missing, Pari? You can always call any one of us with any of these questions. Don't give money back based on something you see in the manuals. And what's that thing again about the argument again?
You should make it. You should make the argument.
Make the argument and make it well. So thanks, everyone, and have a great day.